We provide bold,
legal insight and business leadership
to forward-thinking people and organizations.
We believe in better
and bold outcomes
and meticulous focus
in finding the solutions others might miss.
By building our practice around the best minds in the legal profession.
And outside of it, too.
We believe the pursuit of better starts with people.
Our colleagues, our clients,
and the people who depend on them.
We are committed to truly understanding
the individual needs
of those who depend on us,
so we can help them go from where they are
to where they want to be.
We are.
We are.
We are.
We are.
We are.
Husch Blackwell.
Husch Blackwell.
Husch Blackwell.
We are Husch Blackwell.
Good morning, everybody. Thanks for joining us today. I'm Lydia Chartray, partner with Husch Blackwell, and our team represents condominium and homeowners associations throughout Wisconsin. Before we begin, I'd like to cover a few housekeeping items. At the bottom of your audience console, there are a couple application icons for your use during the program today. Please submit any questions during the webcast via the question box, and we're going to try to answer all your questions during the webcast today, but in case a more comprehensive answer is needed or if we run out of time, please be assured it'll be answered later via email. A PDF of this presentation, as well as a link to sign up for our blog, is available in your resources folder. This program has been approved by the Wisconsin Continuing Legal Education Credit and has been approved by Community Association Managers International Certification Board to fulfill continuing education credits for the CMCA certification. So to report your CMCA hours, click the CEU icon at the bottom of your screen. A certificate of attendance will be emailed to you tomorrow, along with a recording of this webcast for watching and sharing with others. Toward the end of the program, please be sure to complete our short survey. We'll use your feedback to plan future seminars like this one, and hopefully they'll be more applicable to your association's needs if you fill out that survey and let us know what you want to hear about. So that's all the housekeeping items. So let's get started with our program. Today, we will review fine collection, common zoning regulations and practices, the importance of cyber insurance, and recent updates from the Department of Housing and Urban Development on emotional support animals. Joining me today is partner Dan Miskey, who along with myself has been admitted to the College of Community Association Lawyers. Also partner Rod Carter. He has broad experience in land use planning, zoning, eminent domain, tax increment financing, leasing, construction and design contracts, and telecommunications. We also have attorney Kataj Brown. He's our litigation associate for the condo team. Kataj goes to battle for all of our association clients in court when it's needed. And finally, we have our two fantastic paralegals with us today, Sandy Chapman and Billy Fothery. Sandy and Billy are going to be helping us out during the question and answer portion of our program. So with that, let's get started. Dan and I are going to tell you a little bit before we get into the meat of the program about our legal document review. This is a program that we launched in 2019, and over 40 of our association clients have taken advantage of it so far. But I know there's many more of you out there that could really benefit from this program. So Dan, maybe I'll throw it over to you and you can talk a little bit about the program and how it works.
Thank you. Basically, it works like this. You send us all your documents, or in a lot of your cases, we probably already have them. You make sure they're updated so that we have the most recent version of everything. The way the program works and is charged is you pay us, I'm not going to hide the numbers, $5,000 over the course of 3 years, but it includes a lot. So what it includes is we completely review your documents. We give you a scorecard on your documents as to roughly 150 questions as to whether or not they meet the law or don't meet the law. We make recommendations as to mainly two things: items that under the law you must change, and then items you may want to change because we think it would be a good idea. And then also included within the $5,000 that's payable over 3 years, $2,500 year one, $1,250 year two, $1,250 year three, is essentially 4 questions a month, 48 questions a year that we answer. As long as these are phone calls and done relatively quickly. We've included some emails, but our concept is you call us, we give you an answer to those items so that you don't have a bigger problem later. And 1 meeting a year that we will attend either a board or unit owner meeting for up to an hour. So at the end of the day, it's a huge savings to those clients who've taken advantage of it. And I think that's it from my point of view. Lydia, back to you for the rest of it.
Thanks, Dan. Yeah, I think you covered that very well. So if any of you are interested in getting some more information about that program, throw a question in the Q&A box or just send an email to Dan or I, and we will get you what you need. With that, we're going to throw it over to Attorney Kataj Brown, who's going to talk about fining. So take it away, Kataj.
Thanks, Lydia. Good morning. My name is Kataj Brown, and as Lydia stated, I'm one of Husch Blackwell's commercial litigation associates, and I also handle the litigation matters for the condominium and HOA team. And many of you remember me from our previous association academies, and yes, again, I'm staying on everyone about the process of fining and fining unit owners for violations of the association's governing documents, rules, and for violations under the Wisconsin Condominium Act. So this is going to be quick and direct, and but it's going to be a little bit repetitive because we want to drive home the fact that the vast majority of our issues in court come about due to improper fining, which leads to excessive attorney's fees. And even when we ultimately win, the judges tend to not fully award full amount of attorney's fees due to all of the issues with how the associations are applying those fines. So here we go. These are the do's and don'ts of properly fining. Let's go. So number 1, review your documents. I mean, this is a no-brainer. You got to review your documents and make sure everything's in order. Number 2, ask yourself, is the procedure reasonable? Just stop and ask yourself, would a normal everyday person with no legal background agree that your association's fines procedure is reasonable? If yes, then 9 times out of 10, you're good. But if not, that's a major issue and it needs to be fixed. Number 3, are the actual fines reasonable? Use the same test. If an ordinary person walking down the street would find it unreasonable to fine someone $1,000 over parking or trash or smoking or noise violation, then yes, the answer is it's unreasonable, and the fines need to be reduced. Number 4, when the fines are the fines progressive? When fines are progressive, we find that the offending unit owners, they start to pay attention. And that's the whole point of the fines. It's to get the undesirable contact to cease. And ask yourself, can the fines be appealed? We advise that every association should have a built-in grievance procedure that allows the unit owner to appeal the fines at the association level before the matter goes to court. And the reason why we do it this way is because if the association's grievance procedure is final and binding, there's nothing to discuss in court. And the unit owner's claim against the association regarding the fines will likely get dismissed at the onset of the suit. Next, fines and what we need to win in court. To win in court, we need the fining procedure to be followed to the letter. And we also need evidence of the actual violation. What can you do to help? You can help by reviewing your procedure and providing us with evidence to show in court. And what does an enforceable procedure look like? Enforceable procedure basically looks like a carefully reviewed fining procedure that shows all of the fines, that has the fines in increments, that has procedures for notice, and shows how the unit owner was noticed that these fines were being taken place, and shows that the unit owners were also given a warning prior to the fines beginning. Also, a procedure looks great when you have some type of appealable procedure that we can tell the judge, hey, look, we had our own little mini hearing at the association to try to remedy this before we got to court. That didn't work, so that's the only reason why we're here. And if your procedure, like I said before, has that final appeal, non-appealable and binding result, then the judge is most likely not going to entertain a suit brought by a unit owner to a claim against the association to dispute the fines that were already issued. So for court evidence, what do we need? The condominium documents that are authorizing the fining amounts and the actual process that was followed. And we also need evidence supporting the violation. We're finding that whatever the claim may be, whatever the violation may be, something as simple as a couple of pictures or a couple of affidavit statements, sworn statements from some other unit owners who are corroborating that those violations took place, those go a million miles with the court and makes our job a lot easier. Also, due process, like I stated, we would need copies of notice letters sent to the unit owner to let them know that they were in violation of the fines before the fines began. And if there are increments of fines, then notice letters letting the unit owners know that, hey, yesterday it was $25, today it's $50 because you kept doing it. And then due process during the appeal, that's the actual process laid out that I spoke about the grievance committee getting together, reviewing the fine at the association level before we bring it to court. So again, the do's and don'ts of properly fining are having that good fine policy, having that final and non-appealable binding grievance policy, and just realize that every time you do go to court over the issue of on solely attorney's fees, there is a bit of uncertainty as to recouping those attorney's fees because that is left up to the discretion of the judge. That's it, quick and dirty. Thank you.
All right, thanks, Kataj. So back to me, we get to talk about emotional support animals today. Woohoo! HUD put out some new guidelines back last year in 2020, which sort of prompted this idea for this presentation. There's some new stuff out there that all of you need to know. But let's start with a funny. I couldn't help myself. I found this meme and it was so on point. I had to use it in my presentation. I mean, look at that dog's face. It kills me. After listening to his owner drone on for hours, Ralph suddenly realized he was not cut out to be an emotional support dog after all. I mean, really. But service and support animals are not a laughing matter, unfortunately. We can laugh about this right now, but it's important for associations to take these requests very seriously. And you need to know the difference between service and support animals because they are two completely different things governed by different laws. And you need to know how to handle the requests when you get them from owners, residents, and even some frequent guests, because missteps can be very costly for your association. Knowledge is power, as we say. So let's start with service animals. Service animal is an ADA term, so from the Americans with Disabilities Act. And now with the new guidelines, only dogs can be service animals. Used to be that it could be dogs or miniature horses. I don't know if they just figured out that most people don't have trained miniature horses, but it's now limited to dogs according to the HUD guidelines. Service animals have to be specially trained. And I gave a quote from the guidelines there and on the slide. The dog has to be individually trained to do work or perform tasks for the benefit of an individual with a disability. And it gives some examples of what kind of disability that might be. And note that emotional support animals do not need training or certification. So that is the big difference right there. Service animals can be a little bit easier to spot or discern because often the owner's disability and the dog's training, how they're helping this person is really easy to tell. If you can tell what the disability is by looking at the person and how the dog is helping, for example, a seeing eye dog helping a blind individual, or a dog pulling a wheelchair, then it's obviously a service dog. And in that instance, no, the board cannot ask any further information or require supporting documentation because it's obvious. And that's what the HUD guidelines say. However, if the owner has a service animal or they claim to, and you cannot tell by observing them what the disability is, the board can ask for some information. The first question you can ask is the animal required because of a disability? And if so, what work or task has the animal been trained to perform to help the person? Keep in mind, though, that they may have an answer of yes to the first question, but no to the second. Yes being, yes, I have a disability, I need a service animal, but no, this dog has no special training. That doesn't end the discussion right there, because really what that dog probably is, it qualifies as an emotional support animal under the federal law. So we have to continue the inquiry from there. So moving on to support animals. These are the common situations that come up that I get a lot of questions about. First would be an association that has a no pets policy, so no pets whatsoever. And someone comes in and says, I've got this support animal. Can the association just turn them down because their documents say no pets? Well, I think we all pretty much know the answer is no. We have to look into it further. Same thing if you've got a no dog over 25 pounds kind of rule, and somebody says this Great Dane is my support animal and I have to have him. You can't just say no because your documents say have a weight limit of 25 pounds, because support animals do not count for that. You have to look further. Are emotional support animals limited to dogs and cats? The answer is no. I know you've all heard those crazy stories in the news about the turkey on the plane and a kangaroo at a McDonald's or whatever the heck it was. These are real things. These people may actually have qualified emotional support animals that are those wacky animals. So if you get a request, you can't just say no based on the kind of animal. I will say, though, that the latest HUD guidelines did kind of qualify and put a breaking point between common household animals and not so common ones. So I put a few examples on the slide of what's considered by HUD to be a common household animal and the ones that are not. Barnyard animals, monkeys, kangaroos, not common. So there is a different and sort of a more stringent analysis that gets applied to the non-common animal. But again, just because it's a strange animal does not mean that you can say no. You still have to look into it further. Why? Because this is governed by the Fair Housing Act. And the Fair Housing Act finds that handicapped individuals are a protected class, and there's things that we need to pay attention to there. Do support animals need to be specially trained? As I mentioned, no. This is my little doggy, Olive. She has no special training, but I'll tell you, if I was disabled, she would probably be a great support animal. It's just kind of an example of it could be any dog as long as it helps the individual with their disability. Who is entitled? Disabled individuals. Handicapped individuals, again, are a protected class. And handicap, defined by the Fair Housing Act, is a physical or mental impairment that substantially limits one or more of a person's major life activities. Either that or they have a record of having an impairment or being regarded as having such impairment. This slide gives you a nice list of example impairments. And I include this because I want you to see how broad it is. I mean, even drug addiction, alcoholism are considered handicaps, impairments under the Fair Housing Act. So folks that are struggling with those types of issues are entitled to have a support animal under the law. And here's some examples of major life activities, things that might be impaired by their disability. Again, a pretty extensive list. There's not one size fits all for these disabilities that we have to consider. So what do you do when you get a support animal request? First step, if the owner or resident requests an accommodation to one of your rules, meaning you've got no pets policy or you've got a small dog policy and this is a really large dog, the board has to consider the request. So the first thing you do is ask yourselves, does this person, as I look at them, have an observable disability? Or do you already have information that this person has a disability? And if not, you can ask for information that reasonably supports what they're claiming. But be very careful, because Wisconsin has its own law about emotional support animals, and I list the statute there on the slide. In Wisconsin, it says the board can request reliable information coming from a licensed healthcare professional, meaning somebody that's licensed in Wisconsin. The problem with that is the federal law says something different, and the federal law trumps Wisconsin law. So avoid that trap of putting in a policy for your association. They have to provide a Wisconsin doctor's note that shows that they're a patient, they have a disability, and all the rest of the information, because the federal law says no. So in the federal law, it can be from a healthcare professional, the supporting letter, but it also could be just a receipt for disability benefits that shows this person is disabled, and we'll get past that first hurdle. Documentation from the internet. I'm sure we've all heard stories about how you can pay $150 to some doctor, in big air quotes, in California, who will just give you the letter you need for your support animal without having talked to you. HUD apparently is aware that there is some fraudulent activity out there in this regard, but at this time they're not doing anything about it. So if the letter has the information that we're looking for, but it happens to be from somebody across the country, you can't just poo-poo it and say it's not good enough. In fact, a lot of mental health care that's being provided these days is by Zoom and over the internet. So it doesn't necessarily mean it's not actual care. It doesn't actually mean they don't have a disability. We still have to review it. What doesn't count as supporting information, however, are the certificates or licenses that people can just print off Google. For example, here we go. I found this one on Google. Doesn't count. Okay, if you see something like this, this is not a valid thing to show a disability or that a support animal is valid. Even HUD says that these certificates don't count. Okay, so you can disregard them. But here's what you need this supporting information to show. Number one, you have to have information that this requesting individual has a disability that's defined by the Fair Housing Act, and that they have a disability-related need for the animal. And how you establish that is either a letter from a healthcare professional that just generally refers to a disability, say anxiety, but then specifically states what the support animal provides to help that person. Sometimes they'll say the symptoms they help alleviate. So if somebody is suffering from anxiety and depression, the letter may say that this animal helps the person cope, helps them do their major life activities, helps them get through the day. And that's valid. That would be enough information where I would say, board, this person has provided the proof that they need to. Your due diligence is done. You should approve this support animal. Can you ever refuse a support animal request? Of course, yes. If they don't give you the documentation that you need, like we just talked about, or if this particular animal would constitute a direct threat to the health and safety of other individuals. Now, be careful, because it's not enough to say it's regarded as a dangerous animal, so it's a pit bull or an Akita, and so no, we don't want that as a support animal. That won't work. You'd have to actually have knowledge that this particular animal has a vicious past or a record of vicious behavior against individuals. Then you may be able to say no. So you'd have to have some pretty potent evidence in your hand to support that no. Be very careful if you say no, because this can cost a lot of money. Note that if an owner or resident files a complaint and the association ends up on the wrong side of saying no and going through a HUD complaint process, the first violation is $24,000 and some change. And the third violation, if they find you, would be over $100,000. And that's almost nothing compared to the attorney fees it would cost to fight one of these proceedings. And keep in mind, if you lose, you're on the hook for the residents' attorney fees also. So this whole deal can get very expensive very quickly, not even to mention the punitive damages that the court has the power to award. Punitive damages is kind of the sky's the limit sort of thing. So be very, very careful with your no's. Again, attorney fees can often exceed the damage award by a court or by HUD. So it's best to consult your attorney at the outset, before you say yes or no, just to make sure you're on the right track. And keep in mind that then the board, you can rely on the advice that your attorney gives. That protects you. That protects you from fiduciary duty claims and things like that. There's a corporate statute that says, hey, board, if you rely on a professional's advice in making your decision, you've done the best business judgment you can do. So here are my final thoughts and takeaways for this. Assistance animals, according to these HUD guidelines, are not pets. So if you have any rules in your documents that refer to pets, keep in mind those will not apply to any support animals or service animals that may be on your property. So could be a good time to reword your documents to get rid of those references to pets, change the word to animal. That way you know it covers every animal that happens to be on the property. Some associations I know charge a pet fee for having a pet in your unit or in your home. But charging a fee is actually a violation according to HUD. You can't charge that fee for an emotional support or service animal because, again, they don't regard service and support animals as pets. So the last thing you may want to do is consider putting together a policy for your association to handle these kind of requests, kind of a step-by-step thing for yourself, just so you don't have to reinvent the wheel every time. And we know boards change and turn over. So one board may be super educated about this, but then you have new folks coming in and they won't know. So having a policy in place is a great idea, and we can help with that. That's all I got on emotional support animals. Please feel free to put your questions in the box if you haven't already. And now I'm going to turn it over to Rod Carter to talk about zoning.
Thanks, Lydia. You put me to shame with your PowerPoint, so I'll try and keep everyone engaged. I included a little more information. I didn't include a picture of my dog, but maybe next time I'll do that. So I wanted to talk about zoning today, and we've seen more and more zoning issues come up with our association clients. And we've seen them come up really in two ways. And the reason that we thought it was important to talk to you about it today is we have clients who are looking to expand their uses and change and develop what's going on at their properties that are encountering some resistance. But we're also seeing a lot of situations where our clients are being impacted by new developments that are going in around them. And an understanding of zoning law can help you either accomplish the expansion goals that you have, or can help you push back and resist change. And so without further ado, zoning. So zoning in general is a creature of state statute. It's regulated by the state, but then the real power to administer zoning and the zoning statutes flows down to the local communities. And those communities enact zoning and land use laws. So you have county, state, local laws that regulate the uses, the permitted uses of the property, or how easy it is to get those particular uses. And the purpose of zoning law at the heart is to establish orderly development, to assure that properties are going to maintain and increase in value, that communities are going to have certain character and aesthetics to them, and to promote general economic well-being and advancement of the community. And so to do that, communities will enact zoning ordinances. And those zoning ordinances don't only pertain to uses at a particular property, saying that, you know, the property next door to you, you can construct a grocery store or a veterinary clinic, or it's limited to constructing single-family housing. Zoning ordinances include things like regulating waterways. And we see a lot of that with instances where associations are being impacted by a new development coming in, and you get water and drainage issues. All of a sudden, you know, when your development was built, you had an engineer who developed a plan to regulate how drainage and grading was going to occur at the property so that you didn't have stormwater accumulation. And all of a sudden a new development comes in next door and they disturb that, that drainage. And so now you've got a problem. And the local communities regulate or should be regulating and giving some oversight as to that neighboring situation to provide relief if all of a sudden you weren't having water problems and now all of a sudden there's water infiltrations into units, or you've got standing water in backyards and you can't use the property the way that you did. So if you go into the different land use provisions, the local land use provisions, you'll see that they talk about different things. They'll generally have a purpose section that'll explain the purpose behind the provision. And then they'll get into the specifics, and they'll talk about, they establish zoning districts. And zoning districts generally will prescribe what type of land use is allowed in a certain defined area. And most communities have a zoning map that show different districts, and it's color coded, and it'll say you have your, the downtown area is commercial. This area is single family residential. This area would allow for condominium development, and this area is industrial. And they may have varying levels in which they specify those uses. But the zoning ordinance will talk about what are permitted uses in those districts and what are permissive uses in those districts. So permitted uses are those uses that are allowed by right. So maybe the easiest one to talk about as a permitted use is if the zoning district is single family residential, you can pretty much assume that as of right, you're going to be able to construct and develop a single family residential house in that district. Some districts, if you take a more general type zoning, such as commercial, are going to describe what commercial uses are allowed in those districts. And if you think about different commercial uses, there's different intensities of use, right? So a shopping center is certainly a more intensive commercial use than, say, a local bookstore on the corner of a downtown area. So you can, a lot of the permitted uses will spell out in those type of districts more complicated uses and more general uses for the properties. But really where we get in and where we see a lot of issues pop up are conditional uses. And what conditional uses are those uses that aren't necessarily, they carry some risk with them. So they aren't necessarily established uses that you would expect in a particular area, but they carry kind of an added burden. So a conditional use, the community will generally require a series of hearings and public input to approve. Example of a conditional use may be, construction of an office building, because that's going to have an impact on neighboring areas. Or in a retail district, let's take, for example, the retail district that allows the neighborhood bookstore. If you want to construct a Barnes and Noble with a coffee shop, that's a lot different than the small town bookstore. So they would require a conditional use maybe to construct a store or something of that size. You're going to have to go through public hearings and get a more rigorous type approval than if it's permitted. So when you have a conditional use, the community requires that you apply for a use permit and that you go through a hearing process. And that hearing process is a public hearing where they will notify property owners within a certain distance of the affected properties. And those notices come by mail. A lot of our clients have gotten them by mail. There's not a whole lot of advance notice. The state statutes only require a week's notice. So a lot of times what we hear is, well, we just got this notice. We didn't know this was going on. How do we react? So it's important, if you do get a notice that something is going to happen near your property that you aren't in favor of, that you move quickly. Because if you don't move quickly and you don't appear at the public hearing, you waive your opportunity to object. And if you can organize prior to the public hearing and make an effective opposition, your voice is heard and you may have the ability to sidestep the proposed development or get the development modified in such a way that you can live with what's being proposed. One of the issues that came before us recently was an association was located next to a country club. And the country club had been there long before the association. But the country club changed over the years, and the use grew with intensity. And with COVID, what the club found was that there was a need to expand, or that it would be good for business to expand to outside patio uses. And the outside patio uses wouldn't just include serving dinner or serving drinks. They wanted to incorporate live entertainment and things like that going into the night. And they wanted to be able to host wedding receptions and things like that outside, which traditionally had been inside. And the concern of the association was, we've lived harmoniously with the country club, and the country club is great because there's beautiful views of the golf course that we can look out of our back doors. But we never had this nighttime activity in the summer outside, where we like to sit outside on our back porches and enjoy the activity. So there was a notice of public hearing that went out concerning the use, and we were able to mobilize that association to go out and appear at the public hearing, which now in COVID is mostly by Zoom, but usually they are in person. But to voice, they were able to voice their concerns, and they were able to do things like pull records of who had contacted the police department last summer with regard to noise complaints when the club started to do some smaller type outside events, to show that and demonstrate that larger uses were going to have an impact on the community, and it would be a detrimental impact. So after the public hearing, what takes place is that the governing body will consider the proposed use. So usually cities and villages will have a plan commission, and that plan commission focuses on land use issues, and it's composed of a couple of elected officials and then some appointed officials in the community who aren't aldermen or council members, but they have some special land use expertise, maybe architects or engineers, design people, and they're considered to be the experts. So after they get the application, they hear the public hearing, they weigh whether or not this is a good thing, and then they make a recommendation to the Common Council or the village board, who will ultimately make a decision on the request. Now, we talked a little bit about getting notice of a public hearing, and what the statutes mandate is that they post, the communities post notice of their meetings. So that is, you can follow what's going on if you're interested in a proposed development, usually on the website. Most communities have pretty good websites that will show that. And some, if a proposal is particularly controversial, they'll have a special link right on the website where you can get the project documents, everything that's submitted, and review them. They also, as I say, if you're looking for a conditional use approval, the community requires that surrounding property owners within a certain distance are notified. And then for those cases that we see involving waterways, the Department of Natural Resources also gets notice, and will also notify sometimes even a broader population if the impact on the waterways is great enough than just that limited population that the community says has to be notified of the public hearing. So what happens then if you get your conditional use approval? And let's go back to my example about the country club, which, by the way, is still going on. We appeared at the public hearing. The Plan Commission recommended a modification of the club's request that would limit the size of gatherings and the hours of operation. And now it's got to go before the Common Council for an ultimate decision. But what will happen after the public hearing and as the Plan Commission deliberates is that they will attach different conditions to the proposed conditional use. So if it's the Barnes & Noble, they may say, you know, you applied for a store with 100 parking spaces, we're only going to allow 50 to decrease the use intensity. Or they may just ratify whatever was applied for. With the country club example, they elected to modify the hours of operation. So the recommendation was, you know, you can have gatherings of this many people outside. These have to be the hours, and you have a checkpoint where you have to notify the local, the police department if you're going to have outdoor entertainment to make them aware. If you get then your approval, the community will give you an actual permit that spells out those requirements, you know, the hours of operation, the number of parking spaces, every condition that was put on the conditional use. And if you don't follow that permit, it can be revoked. Also, if a community grants a conditional use and it's just the property owner is following the requirements in the permit, but it's just not working out. Say, for example, the country club, and they're allowing the entertainment outside every weekend, and the calls to the police department are horrible. You know, they're increasing every week, and they're legitimate. They're legitimate. And in that case, the governing body can pull the club back in and can reconsider that permit. So if you're opposed to a use adjoining your properties that is ultimately approved, you do have some recourse, and you can keep following up to try and show the local governing body that what they did was the wrong decisions. So then, oh, I skipped ahead in a slide, I'm sorry. There's also a concept of a variance, and a variance is something allowing something that's not allowed in the zoning code. So the zoning code could say, you know, no sheds this close to the lot line. I serve on my local board of zoning appeals in the city of Brookfield, and we recently had a variance request. That's who hears these. It's the Board of Zoning Appeals. We had a variance request for a she shed. And the reason that it came before us is Brookfield allows sheds, but this was quite an elaborate she shed, big and close to the lot line. So the size was a problem, and where the she shed was going to be positioned on the property was a problem. In that case, even though it was a variance, they went through the same process as the conditional use. So you'd get notice. If your neighbor wants, a neighboring property wants something, you know, maybe it's placement of a pool in violation of setbacks, maybe it's a fence around that pool that doesn't comply with the code, you get notice and you have the opportunity to go and be heard before these boards. And, you know, the boards do appreciate getting the public input at the proceedings. So even if you're in support of a variance or a conditional use, it helps to go and attend to support it if you want it, or to push back if you don't. I know when I sit on my Board of Zoning Appeals, there are those cases where you don't quite know how you should vote. For example, the she shed, it's not near me, it doesn't affect me. It's large, yeah, it's near the lot line, but gee, the plans look really nice. And in that case, it really helped that the neighbors came out, and it helped the applicant because the neighbors came out and said, you know, the landscaping here is such that we don't see it because they've got all these beautiful mature spruce trees around their property line, so we won't see it. And, you know, they bought this house, it was run down, and they put a lot of money into it and improved it, and we're sure that the she shed is going to be just great. That helps get you over the edge to support the application. Likewise, if you get organized support against an application, that also helps. I jumped too far. So I want to talk a little bit, kind of some takeaway points. And what you can think about if there is something that you want to do with the association's property that doesn't comply with the code or that would require some sort of use approval. I want to talk about that. I want to talk about what to do if there's something going on next door to your property that you're opposing, and then give you a case study where we effectively were able to push back and prevent a development proposal adjoining one of our association clients. So if you want to do something that isn't particularly allowed under the zoning code, so it's either asking for a variance or it's obtaining a conditional use permit. The most important thing is to start talking with city staff early on and try and establish a good rapport with them. You know, if you can get city staff to buy into what you're proposing, if it's the she shed and putting it closer to the lot line and a bigger she shed, or let's say that your association wants outdoor activities with music. Get staff on your side and talk to them also about, you know, what are the rules? What do I need to be worried about or concerned about here? And even if you don't think that the community is going to regulate what it is the association wants to do, you still should check in with staff. They're there to serve you. You're a taxpayer. They're really working for you. And I've seen situations on the Zoning Board of Appeals where folks have come to us and things have been done after the fact that weren't in compliance with the code. And now they have to ask our permission to keep those improvements there. And if they had just gone to staff in the beginning, they could have eliminated that problem. The other thing is, if anyone in your association has connection to public officials, the elected officials, the mayor, the councilmen, the plan commission members, you know, send out emails and ask that question. And if they do have those connections, use them. Talk to those officials and lobby them to see if you can gain their support. If a public official comes to a hearing and speaks in support of an application, the board is probably going to vote the way that that official says. You know, if an alderman comes to the Board of Zoning Appeals and says, I have no objection to this variance, there's a good chance that the board will approve it. And the other thing then is, for the public hearing portion, get people to attend. We've been involved in cases where we've had one attendee and the association is up in arms and they don't want something to happen, and they're all on the phone with me saying, how do we prevent this from happening? And I'll say, well, we're all going to go to the public hearing tonight and speak, right? And we get one attendee. We've been in other situations where we get 15 attendees, and I'll let you judge for yourself what's more impactful to the folks hearing this than seeing a number of people come out in support of an application. The same way, if you want to oppose something, you know, if something's coming through and you get notice and you do not want this next door to you, you don't want the Barnes & Noble developed, go and talk to staff and say, we're opposed to this, and what can we do? You know, bring several members, see if you can bring several members and have a meeting with staff to voice your concerns. And a lot of times, if staff isn't in favor of the proposal, they'll tip their hat to you as some different things that you can push at to try to get change. likewise, just as you would contact your governing official if you're in favor of something, contact them here to oppose it. You know, we had one recently to wrap up with a real life story where we made a difference. We had an association located next to a resort, and the resort proposed putting in employee housing. The association didn't want that because the employee housing was going to abut the association. And they were concerned with who was going to live in this seasonal employee housing, what sort of traffic impact it was going to have, and the fact that it was just ugly. And they were able to mobilize. So they mobilized, not only did they approach staff, they were communicating daily with city staff, they were approaching the elected officials. And when we went in for the hearings, they showed up in numbers. And they also reached out to other associations in the community and got those associations to come forward and voice objections. And we also developed a contingency plan. If this proposal would go ahead, what could we accept and what couldn't we? But we never got to the contingency plan. We threw the contingency plan out there, but we were able to pick apart enough of what they wanted to do. And we looked at the state. There were some water issues that involved the DNR. We looked at that. We got the DNR involved, but it was sort of a multifaceted approach where at the end of the day, the application was defeated and we won. So I know I threw a lot out at you. If you have these issues come up, reach out to us. You know, we're happy to brainstorm with you. We're happy to chart out with a course for you and be as involved as you want, or involved as much as you want or as little as you want. So thank you. And Dan looks like he is ready to go and ready to talk about insurance. So I turn it over to him.
Thank you, Rod. Very good. Very interesting. So that everybody knows what's going on behind the scenes here, I was going to be really sneaky and be off camera talking about cyber insurance for a little bit and sort of let you know what it's like when you're dealing with cyber insurance issues, because you don't know who's actually doing the acting. You don't know what's going on, and it can be very frustrating. Of course, then when I turned my camera back on, it wasn't working. So up until about a minute ago, I was like, we might not be on this call. So cyber insurance. Here's the simple answer. Do you use a computer? Let's be honest. Most of you, if not all of you, do. A cell phone? Yeah. Do you have a bank account? Yeah. So cyber insurance or cyber crimes apply to you. You know, the options related to cyber crimes, if you don't want them at all to apply to you, you don't even have to do the insurance as long as you only deal in paper, not through your computer, and only in cash, so you're not using a bank account or credit cards or anything else like that. Now, I know there's protections with credit cards so that you could turn them in, or refuse to pay them depending on which account you have and your rights. But what I'm really telling you at the end of the day is you're going to have a cybercrime problem sooner or later. You will have some issue. I think that's what was going on when my camera wouldn't work. Some cyber criminal attacked it, but that's beside the point. So who commits cyber crimes? And this is kind of the interesting part of it, which is, you know, the people committing it, number one is organized crime by far, and I'm checking something here. Yes. Okay. 60% of it's by organized crime. You think it's other states or state actors being, you know, other governments, the Chinese, the Russian, whoever you want to say. No, 60% of it's by organized crime because it's cash. It's cash. It gets moved around. You can't figure out who did it. There's state actors, there's others, and there's insiders. The state actors are just who I just mentioned. The others are, we don't know, is the truthful answer. And the insiders, though, is the interesting one. It's your internal people. It's somebody with access to your system who's stealing or committing the crime, and you don't even know what's going on. So this is really more the purpose of this. Should you have insurance? Yes. Should you make sure you have the right insurance? Yes. Do you need to talk to your insurance agent about it? Yes. I know I harp on insurance a lot, And I know I harp on having an insurance committee a lot because the board nor your property manager have the time to effectively evaluate every single insurance company insurance policy out there, or the ones that you're going to want to. So from your property manager, justifiably, you're going to get those that are generically, in their mind, a good policy. But whether or not it's particularly good for your association is not a fair duty to put on your property manager. If you want to know if it's good for your association, hire either an insurance expert or get an insurance committee that includes some of your insurance people that live on site, and we'll go from there. So I'm hacked. Now what? Notify insurance carrier. Pretty simple answer. Disconnect the network, but don't shut down your computer. Most people think, oh, yeah, I'll shut down my computer and that'll stop everything and I'll unplug it all. No, you're creating a difficulty for the trail. Disconnecting your network makes sense. Don't, once you've decided you're hacked, don't touch your computer other than to disconnect the network. Retain specialists, because it's the only way you're going to find out if you can do anything, and if you can do anything, what. And there's going to be another reason coming up momentarily as to why not to disconnect your network. I'm hacked now with things not to do. Don't contact the attacker. You don't know what you're doing. You think you might, but you really don't. Don't disclose information about the network. Don't pay ransom directly. Don't rely on IT. Okay, so you go, well, why shouldn't I just pay the ransom? Because you don't know what you're doing. If they ask you for Bitcoin or some other coin and you spend the money to go get it and send it to them, you don't know that you're going to get it back. You don't know that it's still not infected. You've got a whole bunch of things you don't know. Don't wipe your devices. You will be creating a problem if you wipe your device for different reasons that we'll get to in a minute. Don't make public statements without legal advice, and don't rely on antivirus alone because it won't be enough. That's the whole purpose of hacking. Is the reason they were able to hack the pipeline is they spend all day, every day, figuring out all the defenses to the hacking and then work from there. I know one of the presenters is not muted, so I'm going to ask one of them to mute because I can hear background noises. So if you're not muted, I'd ask you to please mute. Next one, why can't I just pay? So this is the part I told you about a moment ago, because you're running afoul of the U.S. Treasury anti-money laundering laws. If you pay and don't advise the government, and you should have advised the government, you're potentially violating some acts. And at the same time, you're making it harder for the government to actually help with cybercrime, because the more they know about it, the more they can help with it. So although they might not be helping you, they're going to be helping the next person or the next person or the next person. And therefore, you've got a duty to report, and hence the suspicious activity report that I mentioned, the SARS, MSBs, money service businesses, which is what you're going to be dealing in if you're dealing in cryptocurrency and playing all those games. You need to know what you're doing. Let's be honest. You don't. I'll be honest. I don't. But I know who to call. And the concept is you need to call somebody who knows what they're doing. Protective measures before they steal. You'll notice cyber insurance is on there. Security assessments, technical upgrades to reasonable standards. You know, those are just basic things. The IT covers numbers 2 and 3 specifically. Number 4 is the one you actually can make a difference on. Now, keep in mind, some of these cyber criminals have gotten much smarter. So not only do they infect your system and then sit on your system for a significant period of time. So even though you have backups, your backups might not go back far enough that you'll be able to completely restore your system and not be infected. But you should be able to restore your system to some degree that you can at least continue operating your business. Training, testing, and incident response planning. Perhaps 6 should go back to 4, backups. If you do backups, test your backups. Make sure your backups actually work. run it more than once or twice. Have a schedule. Maybe it's 4 times a year to make sure that quarterly, at least your backups work. Maybe your backups are now only for 2 weeks, going 2 weeks is enough. Maybe it should be 6 weeks so that you can go back far enough. Now, keep in mind, the farther you have to go back, the problem you have is the more data you have to enter just to get back to even. It's a problem, but at the end of the day, you want to have a backup that you know you can rely on. All right. Why cyber insurance covers the financial loss. I mean, you guys get this. Risk can't be completely mitigated through technology. You can maximize your premium dollar with pre and post breach coverage, meaning you want it to cover both losses pre-breach, breach, and losses post-breach. And use a good broker. I wrote in, know what you are buying. This is your insurance committee again. Onward is make sure your cyber policy covers, and you'll notice I cover a number of things here. This is just being careful. That's all this really is. Be careful. Make sure you look at this and go, okay, I know I'm spending $1,000 a year on cyber insurance, and that's a ton of money if you're a 12-unit association. If you're 220 units or 100 units or 80 units or 40 units, it's $20 a unit or $30 a unit. It might well be worth it. You guys can figure that out on your own, but replacing it, remember how hard it's going to be to replace it. So that's really kind of it from the cyber insurance end. I can talk about it a long time because I literally went to a class on it that took 2 hours, and could talk about it therefore for about 2 hours. But I don't think that's the point. The point is really to make sure you guys are doing 2 things. Have an insurance, or 3 things. Have an insurance committee, have cyber insurance, make sure you have backups and test them. I mean, if you do those 3 things, you are ahead of most people. It at least puts you in a position where when the problem arises, you can do something about it. What we learned today, find policies, you need them. If you don't have a policy and you don't have a schedule of fines, you risk that they are not going to be enforced by the court. Evidence. You need evidence of what you actually did to give people advance notice of both the policy and that what they're doing is wrong. So normally a warning letter, depending on the event, followed by progressive fines. Emotional support animals, you know, what they are, what they aren't, when you can do something, when you can't. The fact that emotional support animals are covered by the Fair Housing Act and the Americans with Disabilities Act deals with different types of issues in animals. It deals with service animals, mainly dogs, like almost only dogs at this point. The various zoning issues that Rod Carter talked to us about and what you can and can't do, and then the cyber insurance. I mean, if you get hacked, when you get hacked, hire professionals, make sure you guys do that. From our standpoint, we're kind of done, but we're happy to talk about any questions, read some questions. This is where our paralegals come in and help us out and tell us what our questions say. And then one of us will answer them depending on how many we have that are still left unanswered. All right. I will turn it over to Sandy or Billy.
Okay. Let's see what we have today. Can everyone hear me? Good.
We can.
Okay. Back to the AED machine. Does the Good Samaritan law cover any assumed liability?
That was a question that I answered earlier. Could you read that one again? I'm sorry.
Back to the AED machine. Does the Good Samaritan law cover any assumed liability?
This is, I don't remember what the AED machine is. But
Billy, maybe you can read the other question that came from, I think that was from Nancy. She had a preliminary question and then that follow-up.
Well, that must still be hidden because it was answered. Let me go back and try to find it. In the interim, I'll move on to a different question and we'll come back to that one. Our association is, this might be the same one. This is another one about the AED machine. Let me go here. Okay. Unit owners can use our community room with a security deposit of $250. At a recent event, a child put a hole in the plaster wall. Our maintenance man fixed it, though we have called a contractor. The board fined the unit owner the full amount, even though, sorry, this is broken up a little bit. Even though, so the maintenance man fixed it, though they had called a contractor. The board fined the unit owner the full amount, even though the repair costs could not be documented. I'm assuming because the repairman did it. Is there a responsibility to match the fine to the violation?
Kataj, you want this or you want me to go?
You can have it, Dan.
All right. So you're going to have a couple of problems. One, it's obviously not going to be scheduled. Two, so you've got one issue is the cost of making the repair to damage done by a unit owner or guest of a unit owner. That's going to be easy. Go, yeah, they caused the damage. Here's the proof. Here's a photo of it. And therefore, as long as your documents say that should that take place, the unit owner is responsible, you can collect the cost of making the repair. Now here you have the problem. The cost of making that repair were zero or next to zero. That's issue one. Issue two is, do you find, because that's a cost issue, a direct cost issue that you pass back to the unit owner. It's not a fine. It's you assess them the costs of the repair as an assessment because it's probably covered by your documents in that fashion, depending on how your documents read. On the other hand, a fine would be, the rules are you can't damage association property, you damaged association property, therefore we're going to fine you under our fine policy. And although our maintenance man fixed it, and it would have cost $222 had we used a contractor to fix it, our fine is $50 because that's the first fine we give people, or you give them a warning and then you don't fine them. But keep in mind, if you fine them, you're going to have to back that fine up. And ultimately, that's going to go to court. And you may have a judge that says, you know, you fixed it, it didn't cost you anything. They pay their proportionate share. Your maintenance man, you're stuck. Or the court could say, well, they did have advance notice that you can't damage association property. They clearly damaged association property. You could have let a contractor fix it, which would have cost them $222. You had a duty to mitigate the damages. You did, and therefore the fine of $50 is reasonable, and I'm going to let it go. I could see a court saying either one of those. I think more likely the second, but those are all the options. All right. Next, Billy.
Okay, so going back to the original question, it was if a service animal owner, and truly any owner, thinks they may be having a heart attack, is there liability in dispensing aspirin? So that was the original question.
Wait, and let me help. And the answer was yes, because there's always liability if you do harm. And the rest of my answer was, if you're going to, quote, dispense aspirin, hence give medication, I wouldn't dispense it. I would make it available and go, we have aspirin. If you want to take it at your risk, it's here. We have no idea because we're not doctors. Okay, next part.
So going in that using the AED machine, and they further wanted to know, does the Good Samaritan law cover any assumed liability for having that available?
The Good Samaritan law works under the principle of if I try and I fail, it's okay that I tried. It doesn't work under the principle, I tried, I made things worse, and therefore I'm protected. So I believe the Good Samaritan law is not going to protect you from risk of liability because you did something. That said, which is the rest of my answer, you are a human being, someone suffering, you are going to likely try to help. in the back of your mind, you should have in there, let's not do more harm than good. So if we don't know what we're doing, call 911. Let them tell you what to do, and then you're protected, or not do. There's a reason 911 dispatchers don't tell you normally do X, Y, Z, but rather say call, an ambulance is on the way.
Okay, good. Because we did have another question about AEDs, but I think that answered that one as well. So we'll go on to our next question, cyber insurance. How does the board find a reliable cyber insurance carrier or policy?
My answer is you've got to have an insurance committee. It's going to be the same people that are going to provide you with your basic general liability policy and your property damage policy. It is literally the same people. So I could name some. I know State Farm, I know Travelers, I know American. I mean, but I don't know enough about each one of their policies to give you a fair answer, but that's where I would start. Next one's Lydia's, no matter what.
Also, take a look at the list of insurance companies that are affiliated with CAI, because those ones are specializing in condo insurance specifically, and you probably have a much better luck that they understand what cyber insurance is for an association as well.
Good idea.
This is an interesting one. If an owner renting out their condo, and the owner is renting out their condo, a friend of the renter crashes into the front of the garage doing heavy damage, who is responsible for paying the damage? The car owner does not have insurance. The owner says they are only insured for the interior of the condo. Does this make the association responsible for payment?
I'll take a stab at this one. And this one definitely sounds like a law school exam question, so it's giving me some flashbacks. But I would say, this is going to be a very fact-specific answer to the question, meaning that, we would need a couple of more facts to decide this. First off, there would have to be some kind of concrete connection between the friend of the renter and the renter to show that the friend was actually an invitee or somebody, brought onto the property, invited onto the property as the friend of the renter, right? Because it's the easy way to refute this is to just say, I don't know who that person is and they crashed on their own. That's not my friend. And that's most likely what most people would say. So there would have to be some kind of evidence, whether it be, video evidence, maybe of a security camera of this person coming in and out of that person's unit, whatever the case. But we would have to draw that connection to show that that person was actually invited onto the property and invited as a guest of that renter. And if we could tie that together, then we could make an argument that the renter should be liable. Now, if the renter is liable, this may flow into the tenant. Into the actual owner of the unit covering the damage. So I think so. We would need a little bit more facts to flesh that out, but I think the connection is going to be whether we can prove that that person who crashed the car was actually a guest of the renter.
Yes, they went on to say the person was there to pick someone up, so it appears they were invited to the property.
Right, and again, right, I mean, just knowing that is good, but convincing a judge in court that and that's the actual truth, and then having the other side say that's not the truth, that's a whole nother story. So again, anytime that there's any damage, anytime that any rules are violation, this taps back to what I was saying about having that evidence. It's so much easier to prove these things and help the association out when we have concrete evidence, whether it's through affidavits, whether it's through sworn testimony, whether it's through video, picture, whatever the case may be. Anything that we can have to supplement our argument with hardcore facts and evidence is going to help.
So let me cover the rest of that as well. I completely agree with what Kataj said for a starting point, but I want everyone in this audience to think about this for a second. You'll call a friend to pick up your son, daughter, who comes and drives into the garage. You certainly didn't tell them to drive into the garage door. And there'll be no evidence that you did, I presume. Okay. On the other hand, I call an Uber driver a taxi, and they drive into the garage door. Am I expected to pay because the Uber drivers or the taxi driver drove poorly? The answer is likely no, and likely the insurance has to cover that. So what's the difference? The difference is I have some relationship and happen to know the person that I'd called to drive them, and they happen to drive poorly. Your claim is against that person, and I think making that connection to the tenant, unless the tenant did something negligent, jumped out in front of the driver, and the driver drove sideways into the door to avoid the accident, I think you're going to have a hard time suing the tenant. Hence, the owner's going to be safe too.
We'll switch gears a little. When handling collection issues via mail, should letters be written on association letterhead, or is management company letterhead accepted?
I think, Billy, this is you.
Actually, I answered this one on the chat, so I can certainly let everybody know what I said. In my opinion, it's fine that the letter comes on management letterhead. The key, though, is either way, the management company, if writing the letter, needs to indicate that the letter is coming on behalf of the board of directors. It's not coming from the management company. It's not the manager's decision. It's actually on behalf of the board. The board makes the decision, and the manager just carries out the function of sending the letter.
Okay. Our association has recently updated its docs, including a progressive fine schedule. Okay, I think this was just in response to something else. There's actually no question there. My apologies. My apologies. Board voting by email. When you say unanimous, does that mean that all board members must vote yes or no to move forward?
Yes.
Yes. I'll take that one. Yes. Unanimous is everybody. Absent something in your documents to the contrary, if you're going to try to vote via that way.
Right. And this one actually comes up quite a bit because I know it's difficult for boards to get together all the time. Anytime anything comes up, things do happen between board meetings that are scheduled that you need to deal with. So as long you can do it by email, as long as all board members weigh in and all board members agree. So if you run into a situation where one board member is like, I'm not really sure if I want to vote yes on this, just call a quick special meeting of the board, get on a call together, a conference call, talk it out, vote on the phone. That way you don't have to be unanimous to move forward. That person could still dissent. You've had a meeting technically, and you can move forward on it. And always, if you do anything by email in between meetings, your best practice is to make a note in the next meeting's minutes of all the actions taken in between, so you've got a good record of it.
We are actually out of questions, so if anyone has any more questions, feel free to type them into the box.
Cool. Or if Sandy or Billy, if you guys see any questions in there that you think are good or pertinent to the group, have already been answered, you can throw them out there.
When answered, did they go out to everybody or just to the person who asked the question?
Could have been either.
Okay.
Yeah, and don't worry about it because we will likely have far more to say than we wrote into the answer.
Well, a couple new questions came in. Is there any law preventing an association from prohibiting smoking in a condo building, including individual units?
Oh, good. Can I take this one too? No. I'm good on one-word ones. We've dealt with this a lot. The board controls your association. The board can set forth uses. Uses are supposed to be, at least according to the law, in your bylaws or in your declaration. But let's be honest, every single rule is a use control. So My basic answer is the safest way to do it would be if you want to prohibit smoking throughout your association, including in the units. There's nothing that prohibits you from doing it. You might get a lot of pushback, but there's no law prohibiting you from doing it.
Right. So you just need the amount of votes needed to change your declaration or bylaws by the owners in order to pass it. A lot of associations deal with the issue of the pushback by putting some sort of a grandfathering provision in there for the smokers that live there now, giving them a number of years, or having the folks that smoke self-identify as a grandfathered person, because sometimes you don't necessarily know who the smokers are in a building. So there's lots of different ways to handle it, but I agree with what Dan said. It's best if you're prohibiting smoking within units to put those types of rules in the declaration or bylaws. Common area prohibitions, keep them in your rules. They'll be enforceable all day.
I think there was a problem with someone receiving an answer, and she has asked if we could just briefly go over it again. Can we make restrictions for emotional support animals, such as being in the common areas, if owner has access outside without going through the common area?
Right. As I understand the question, folks could take their animal outside through an elevator or some sort of mechanism that you don't have to walk through the big common area in the middle. I know this property really well, where the question's coming from, so I have a picture in my mind. So the answer is yes. I mean, as long as there's a reasonable way for the animal owner to get their animal outside, you can restrict how they bring the animal even. You can put rules in that say they have to be in a crate or on a leash, in control of the person, just like you would with any other pet type of a rule. And you can say that they can't be in that main common area, as long as it's not too restrictive or unreasonable for the animal owner. So again, if they can access the outside without coming through the common area to have the animal relieve themselves, great. I don't see any big unreasonableness associated with that kind of a rule.
Can they restrict the area where the animal can relieve itself, and if it's not complied with, fine them?
Same answer. It would have to be, that kind of a rule needs to be reasonable as well. You can't pick up a spot that's 50 feet, way off the property, away from the building. Let's face it, we live in Wisconsin, and who wants to have to traipse through in 50 below weather to get that far? So that kind of a rule wouldn't be reasonable. But I think if there was a designated area for animals on the property that's close and easily accessible, that could be reasonable. And again, if you have that rule and folks aren't abiding by it, then yes, you can fine. That applies to emotional support animals and service animals also.
Just one more question on that.
Wait, 1 second. I want to add a little to what Lydia said. I agree with what she said, but keep in mind, and I know everyone on this call knows this, emotional support animal owners are owners of animals because they have emotional issues, and sometimes, or disability issues, and sometimes those issues manifest themselves in things that you would think might otherwise be unreasonable, but they're willing to fight to the mat to it. For example, we've had situations where someone wanted their dog, who was an emotional support animal, to be able to go into the swimming pool with them, even though it would cause them to then have to shut down the pool, because the health inspector said if the dog goes in, the pool's getting shut down. And they still demanded that right, and were willing to go to the FHA and argue about it. So I'm just saying, whatever you pass, make sure you want to spend the money to enforce it. Or if you can live with it, you might want to consider living with it, because there will be an economic consequence associated with the restrictions you place, maybe. Okay.
What if that same animal barks excessively? What do you do then if the dog just won't stop barking?
The rules are the rules. I mean, this is Lydia's area, but the rules are the rules. Even an emotional support animal, you can have rules then for animals, including which would apply to emotional support animals, and noise violations or noxious behavior. That rule could exist, and then they need to find a different emotional support animal. I mean, it's going to be a fight, but so is staying up all night.
Thank you.
Right. And the other they want to add on to that is, again, this highlights the importance of using the correct wording in your documents. If you've got a rule that says pets can't bark excessively, guess what? That's not going to apply ultimately to an emotional support or service animal. So if you change that one word from pet to animal, you're much better off, and your rules would be enforceable against all animals.
Great. What if a board makes a lot of decisions behind the scenes? Is there more that needs to be done to ensure they are following the rules?
Okay, a board can literally meet all the time in closed session, literally all the time, unless your documents say otherwise. That said, the best practice is to never meet in closed session unless the law sort of requires you to meet in closed session. So dealing with personnel issues, dealing with medical issues, dealing with bidding on contracts, and probably, and attorney-client privileged items. That's it. Otherwise, our advice, and this is pretty universal nationally, have open meetings, because there's nothing that makes people think you're doing stuff illegally than having a closed. And there's no purpose to it. Make every meeting open to everybody and no one will want to come. It's when you close the meetings, everyone wants to go.
But Dan, they want to close the meeting because these people are annoying and they keep coming and sitting there and disrupting the meeting. So what do you do with those owners that just want to interrupt the board meeting all the time?
So thank you. And that answer for me is easy. This is how you run the meetings the same way. The meetings, I would have a time limit. It's 90 minutes. It's not 91 minutes. It's 90 minutes. The unit owners get 15 minutes or 10 minutes, whatever seems reasonable at the beginning, to make comments. Notice I'm saying unit owners can make comments. And the reason I say at the beginning, so if they do bring up an emergency, the board can actually deal with it during the rest of the meeting when the unit owners cannot talk. This is not 15 minutes of discussion back and forth or question and answer. This is unit owners get to comment, board does not talk. And then the unit owners are done, and then the board moves on with its meeting. And if there's something they got to cover, great. If there's something they don't need to cover, fine. But if you got something to cover it under new business, go, unit owner X brought up Y. I think we should deal with Y. I'm going to make a motion. We put a stop sign in. Oh, I'm going to second the motion. Okay, then the board can have a discussion. Why does, the person X does not get to say another thing unless somebody from the board asks them a question or something, which you can do. But keep in mind, inviting unit owner question and answer time tends to eat up your 90 minutes. Okay, that was it for me.
An association wants to change their bylaws to eliminate rentals and become only owner occupied. Is this reasonable?
Yes. It is. But, when we do amendments like that to the bylaws, and that's great they said bylaws, because that's exactly where these kind of rental restrictions should be. You can't just put them in your rules and expect them to be enforceable if you're saying that owners can't rent. There's a Supreme Court case on that from years back. But anyway, a lot of associations, when we draft these kinds of rules, will put a special hardship clause in there as well. So that, yes, you're saying no rentals, that's a reasonable thing, but we never know what the future may hold. And we may have a situation where the market crashes again and folks can't sell their units because they're underwater with their mortgage. Things come up with military service too. There's things that do come up legitimately where the board may want the ability to have some discretion and allow a short, like a 1-year term rental in certain situations. So that's a good idea to have in there just in case. But certainly you can, if you get the votes, you can say no rentals.
Thank you, Lydia. This board doesn't want the expense of formally changing their docs. So we just published changes, and now owners are saying the changes cannot be enforced since they were not voted on.
And we have 1 minute left, so this will be the last question, because you know I said start on time, end on time. But this is Lydia's question, clearly.
I answered this one actually for the person that posed it. So yes, unfortunately for this board, formalities are important. The law requires that the certain formalities be followed if you're making changes to your bylaws. In fact, the statutes say you have to have 67% of the total unit owners approve before you can change any bylaws. And rules and regulations may be able to be amended and passed by the board alone. But again, that's a function of what your documents say. So these formalities do matter. And if you pass rules and bylaws without following those formalities, then they certainly are subject to owner challenge. So they might not be found enforceable by a court. Best practice would be to talk to an attorney that knows what they're doing and get some guidance as to how to make these changes, in fact, enforceable. And that's it. Thank you, everybody. Dan's got some closing comments, I think. Right, Dan?
Yes, I do. Oh, good thing you said that. I would have skipped those. Thank you for joining us today. We hope the information that we provided was helpful to you and your association. This program was approved by the Wisconsin Continuing Legal Education Credit and has approved by Community Association Managers International Certification Board to fulfill continuing education requirements for your CMCA certification. To report your CMCA hours, click on the CEU icon at the bottom of the screen. A certificate of attendance will be mailed to you tomorrow, along with a recording of the webcast for watching. Be sure to complete our short survey, please, please, please. We use our feedback to plan future programs that are applicable to your association needs. And this concludes our seminar. Thank you guys so much for attending. Have a great day.